I was on the Bigger Pockets forum, and I noticed a post from an investor that made a very strong argument that if you are a California resident and own California rental properties, or if you're a California resident and own out-of-state rental properties, that you should only use California LLCs. This Bigger Pockets post is critical because protecting your rental real estate through LLCs is a critical step in making sure you can grow as a long-term investor. I'm Jeff Hampton, asset protection attorney, best-selling author of The Investor's Blueprint, Asset Protection Made Simple, and the founder of STR Law Guys. In this video, we are breaking down the exact steps you should take if you are a California resident and own rental properties in California, or if you're a California resident and own rental properties in other states, what exact steps you should take so that you can make sure you are protecting your rental real estate. Stick around, because following the wrong advice here could not only cost you additional fees and maintenance requirements, but also could cost you everything if you end up being sued by greedy lawyers. Let's see exactly what this Bigger Pockets post said. Max said, I'm in California, and the most common LLC related question I get is, I live in California, I want to buy properties in other states. What state should I open an LLC in so I can save money? I don't know what state you live in, but if you live in California and own rentals anywhere, you have to have a California LLC. In California, you are legally required to have a California LLC if you are, quote, conducting business in California, end quote. Even if you own a property in Texas, you are conducting business in California because you live here, collect the income here, etc. If you do have a Texas LLC just to hold a Texas property, you still have to register in California as a foreign LLC, which still means paying the California LLC tax. So there's no point in having an out-of-state LLC in that scenario. I would imagine other states have similar laws, but I do not know for sure. You should consult a business attorney in your state regarding this. But my point is that it's not as simple as just finding the cheapest LLC state and opening an LLC there just to save money. There are no free lunches, man. Now, Max makes some good points here, but we have to be careful. If we worry too much about that annual fee in California, it could cost us everything for asset protection. Now, let's start with the obvious. Property rights and property law in California is terrible. If you own rental property in California, unfortunately, the odds are not in your favor because the laws are written specifically to favor the tenant, even the short-term tenant under a short-term rental. Even worse, California LLC law is so bad that many California judges have found arbitrary reasons to pierce the veil of your LLC, which now allows greedy lawyers to potentially sue you and not only get access to the rental property that you could lose in the lawsuit, but now potentially get access to your personal assets. So what do we do here? Step number one, if you own rental property in California, it is critical that you set up a California LLC to actually own the asset. However, be careful in California, because if you fail to close in an LLC at the time you purchase the property, California will assess what's known as a real estate transfer tax when you decide to transfer the property from your name into an LLC, unless you use a land trust. And this is important because a land trust is a wonderful tool that will help you avoid this tax, because in California, the tax is over 1% of the value of the property. To learn more, I cover this in depth on some of the other videos that are on this channel, so make sure you check them out. Now, it is true when Max said that California charges a ridiculous annual fee for your LLC, he's right about that. However, if your property in California is sued, you must be aware that California law will control, because jurisdiction is determined based upon where the property is located. If you try to avoid this by using another state's LLC at this stage of asset protection, it will do nothing but be a waste of your time and money and actually cost you more money for maintenance over time. Now, here's the key difference though. What if you're a California resident and you own rental properties in other states? Should you do like Max said and use a California LLC for those out-of-state properties too? Absolutely not. It is true that California will still charge you that annual fee for owning rental real estate in another state. However, if you use a California LLC to hold property in, say, Florida or Texas, not only are you going to be wasting your money setting up a California LLC, because honestly, the law in the state where the property is located is going to control, but now you have a foreign LLC with a California LLC that you now have to pay registered agent fees in both states. And you're going to have to pay more over time for the maintenance. And more importantly, you receive no extra asset protection. So what is the solution here? We've already learned that California LLCs provide you very little actual asset protection for properties in California. And we've also learned that California LLCs do very little to protect any of your properties out of state. So now that brings us to step number 2, the holding company solution. If you own property in a state with poor LLC laws, like California, the only way to protect those assets while maintaining flexibility and those wonderful tax benefits we all want is to consider using a holding company strategy. Here is how it works. Number 1, if you own a property in California, you would set up a California LLC. If you own property outside of California, you would set up an LLC in the state where the property is located. If that state is like California and has terrible LLC laws, now what you do is set up that California LLC, but instead of making you the single member on that LLC, you can make a Wyoming or Delaware LLC the single member. Why? Because these two states have some of the strongest laws on the books anywhere in the country that provide 3 of the most important aspects you want for asset protection. They provide privacy from the eyes of greedy lawyers. They provide what's called charging order protection, which helps you from losing the asset. And then finally, they provide you single member LLC protection. In other words, these two states actually provide you asset protection. By making that Wyoming LLC or Delaware LLC the single member of your California LLC, here is what happens if you get sued. If I'm the attorney bringing the lawsuit, the first place I'm going is to the California Secretary of State. When I get there, there's only one member listed on the LLC, and that is a Wyoming LLC. So the Secretary of State will now direct me to Wyoming. When I get to Wyoming, I'll learn, Wyoming will tell me, we have privacy laws. We cannot disclose to you the name of the member or the manager listed on this Wyoming LLC. I will also learn you have charging order protection. This means if I sue you and I win, I can't actually make you sell the property. In other words, you can continue to rent out the property, pay all of your expenses, and as long as you don't pay yourself an owner's distribution, you could literally wait out the creditor, meaning the lawyer, and that makes a significant disincentive for the attorney to want to sue your structure. In fact, one of the main goals in the United States when it comes to asset protection is to make the easy button your insurance settlement. So that way that greedy lawyer is not trying to hit a home run by going after all of your properties. And by the way, this works very effectively because all attorneys that take what we call premises liability lawsuits only take them on a contingency fee basis. That means the lawyer pays for all the expenses of the lawsuit out of their own pocket, and they only actually make money if they can collect. Well, if I can't make you sell your property and I won the lawsuit, I still kind of feel like I lost. So in that situation, you're incentivizing the lawyer to actually go for the insurance settlement instead of trying to go after you. Notice what we did here. We made sure that we could protect our rental properties both in California and outside of California. We also made sure we have true, legitimate asset protection by using a holding company that provides privacy, charging order protection, and single member LLC protection without overly focusing on the annual fee that California charges for their LLCs. Now, if you're a real estate investor and you want to protect your assets from greedy lawyers, we provide a free consultation to investors. Check down in the description section and look for the link below, or you can download our free ebook, The Ultimate Guide to Protecting Your Rental Real Estate. Finally, if you want to do a deep dive here, check out The Investor's Blueprint, The Asset Protection Made Simple, our best-selling book, and it's available down in the description below. Now, what if you have multiple properties in different states? Will this strategy still protect you? Maybe, but you have to watch out for the fraudulent transfer analysis. What's that? Check out this next video where I break down exactly what it is and the strategy you can take to protect your growing rental real estate portfolio. See you over there.